Welcome everyone to our webinar today on legal tips for small businesses to win enterprise and government contracts. My name is Ushna Bashir and I am a lawyer here at LegalVision, and today I'm joined by my co-host Stephen Drysdale, who is a practice leader at LegalVision. We are both in the commercial contracts and regulatory compliance team. Before we begin, a couple of quick housekeeping items. So after this webinar, you will be receiving a recording and slides in your email. You are able to submit your questions. Any questions that you've got, feel free to pop them into the Q&A box and we'll try to get to them towards the end of the webinar. And please, after the webinar is complete, send through any feedback that you might have, and that'll help us improve any future webinars that we conduct. For the next 48 hours after the webinar, you're also eligible for a free consultation with LegalVision to discuss how we are able to help your business. So at the end of the webinar, feel free to send through your contact details and we'll get in touch with you for a complimentary consultation. So today we're going to be discussing some of the ways that you can increase your likelihood of winning enterprise and government contracts. This includes focusing on your business structure, your internal and external contracts, your resourcing and staff, regulatory compliance requirements, and also general housekeeping. And then, like I mentioned earlier, we'll finish off with a round of Q&A. And so I'll pass off to my colleague, Stephen, to start us off with discussing the importance of having the correct business structure in place.
Thanks, Ushna. Before we dive into the different types of business structures, it's really good to understand why that business structure matters in the first place. And this is more of a general consideration from a general contracting and business perspective, but kind of flows through, when we're dealing with these government and enterprise contracts and sometimes the risk or the scale that these contracts can entail. So business structure can affect a few things. So tax is sort of one thing, whether, it's a company or some other structure being taxed versus maybe you and your personal income. Also in terms of liability. So when we're talking about things around who is liable for, non-performance or poor performance under a contract, is it, you in your personal capacity? Is it your company? Is it someone else? Sometimes your business structure too can influence what sort of funding or capital you can have access to. And also as well, the way in which you contract, you may have, more divisions in your business that you've split out into various companies or into various structures, and that will sort of flow into how you contract or engage with other businesses. So it's really important to get that sort of right earlier on, because it can be quite hard to change downstream, and it also can have tax consequences and other considerations too. Some of the common structure options you'll see in Australia, things like a sole trader, that's sort of the easiest one. It's sort of you in your personal capacity running a business. You might apply for, or usually would apply for an ABN, and you simply set up your business and you get to work. You typically have full liability because it is just you in your individual capacity and there's no layer of separation. A partnership sometimes appears when you've got, say, one or two people who have sort of joined together to form a business. They've agreed to maybe share, profits and losses, things like that. And sometimes they might formalize that arrangement into a partnership agreement. Sometimes it's sort of more on an informal basis. These sort of arrangements can have a varying degree of risk. So, partners usually are jointly liable unless, it's set up in a different structure. They can be more complicated from a contracting point of view, and just from a general, ease of doing business can be a lot harder to manage, which is why when sort of you have multiple people wanting to come together, it's quite common to opt for a company. And that's because you can get that limited liability between your directors and your sort of shareholders, owners of the business, and the actual business itself. And some people will go sort of a step further and set up these corporate structures to separate liabilities within the business as a whole. So if you're in an industry or you're thinking about applying for maybe a high-risk government or enterprise contract, you might be considering, maybe setting up a subsidiary for that purpose. It's quite common in sort of large infrastructure projects, sort of roads, tunnels, things like that, for large development companies to actually set up a sort of a special company or a sort of maybe a joint venture company with a government agency or just a separate entity of itself to run that project to try and add another layer of separation between that activity and the wider group, so that there's, I guess, less risk of something maybe following its way up the chain. And then the last one that we often see sometimes is a trust. They're usually used to protect assets. You see them quite commonly in sort of personal wealth and sort of private affairs, but they are common in business as well. They're a lot more complex to run and sometimes to do business with, which is why, again, a company is usually the preferred approach just for business ease. But there are tax considerations between the two, which, you know, I'm sure your accountant can walk you through the ins and outs from a tax front on that point. And then I guess just some further considerations. So we sort of already mentioned the type of business and the risk profile, and your growth plans is obviously quite important. So international expansion, you know, companies are really easy for that sort of roadmap. Other structures can be a bit harder to translate, don't exist in those other jurisdictions. And also, you know, how you work in terms of the business around decision-making processes and the involvement of others, especially too if we're talking about these high risk or high value contracts with government and enterprise. You know, having really clear structures within your business, a really clear organizational hierarchy in terms of decision-making, in terms of things like who can sign off on these contracts, who can make decisions around, you know, maybe amending a scope of work. Things like that are really important to get right so that things don't, you know, necessarily maybe creep, or, you know, there's not sort of a blowout on budget or costs that weren't foreseen or accounted for. And then the last sort of point on that business piece is just around the actual general registrations and certifications for your business. So it's really important to have your licenses and permits all up to date. That's the sort of thing that's kind of a fundamental consideration when you're looking to apply for these sorts of contracts. If you can't lawfully do the business, then you're not likely to win those tenders. And then in terms of, I guess, actually coming across those tenders and how you can kind of be across what's happening, there's a few places to look. So AusTender is the main one for sort of your federal, your Commonwealth, your large contracts. But each state and territory also has their own tender portals as well. For example, New South Wales has e-tendering, and each state will have its own sort of requirements around, you know, how it, I guess, looks for new business or new suppliers, and that will usually be set out in each request for proposal that they'll put on those tendering websites. So really important that you actually, you know, for government contracts, that you subscribe to those services, and that you're kind of across what's coming through as they get published, especially too, because some of the turnaround times, you know, the contracts you have to review and the kind of timeframes that you might be given can be quite tight. So it's just really important to be across them as they come through there to give yourself the best opportunity to succeed. I'll pass to, I guess, speaking of contracts, I'll pass to Ushna now to speak about those contracts that are really important to have from a business standpoint, and what you might expect to see when you're kind of dealing with these sort of government enterprise clients in the contracting space.
Thanks, Stephen. So obviously, as contracts lawyers, the both of us, it's probably no surprise that we're really going to emphasize the importance of having the right internal and external contracts in place. This is important for a few reasons. Obviously, it makes you, you know, really safeguards your business because it means that your interests are protected, but also it demonstrates a lot of professionalism and expertise to enterprise and government clients, which is really important when you're really trying to, you know, bid for those important large jobs. So what we'll do is we'll discuss both internal and external contracts at a really high level. From an internal contracts perspective, you want to make sure that you've got the right employment agreements in place. Again, this shows to potential clients that, you know, you're following processes, you've got good relationships and good checks in place with your employees. And also it means that you're probably increasing your employee retention, which is seen as a positive sign of stability and continuity by third parties. You also want to make sure that you've got workplace policies in place. So some examples of these might be IT or surveillance policies, anti-discrimination policies, harassment and bullying policies, and work health and safety policies. This shows that you're going to be compliant with the relevant legislation and regulations, and we will touch on that again a bit further down in the webinar. And again, if you do have those right contracts and policies in place, it also shows to those government and enterprise clients that their IP rights will be protected and will be kept confidential with any employees that you're engaging, which is really important. On a similar front, you want to make sure that you've got the right contractor and subcontractor agreements in place. This is really important because obviously if you've got a gap in your expertise, it'll assist you in delivering the right services to enterprise and government clients when you've got the appropriate contractors in place. And importantly, with those agreements, you want to make sure that they really align with any head contracts that you've got with the larger entities. And so what that means is really carefully reviewing those head contracts and making sure there's nothing in your subcontractor agreements that is at odds with it. And also that if there are any flow down clauses, they are passed down. So for example, if there is an obligation from the enterprise client that you comply with modern slavery provisions, you want to make sure that that obligation is passed down in any contract you have with your contractors and your subcontractors as well. In terms of external contracts, I mean, you know, we could talk about this forever. There's just so many that you want to make sure you've got in place, but we'll talk about some key ones today. So a really important one, and often the first contract that you might sign with these entities is an NDA. An NDA protects the confidential information of either one or both parties. And it's usually entered into before you sign that substantial services agreement. So why this is important is it's really comforting for these larger entities to be presented with an NDA or also to present you with an NDA and see that you're quite open about signing it, because they're often quite cautious about sharing confidential information. And so they you know, receive that legal assurance from you then that their information will be safeguarded. And this then builds trust and, you know, a higher chance of building a relationship moving forward. Obviously, another really important one is the master services agreement or the head contract that you sign with these larger entities. Now, obviously, and, you know, more often than not, they will be the ones that will be presenting you with a contract. And in those instances, what you want to do is make sure that you've got a lawyer that's looking through those contracts. Make sure that you've got some sort of commercial playbook in place, or a list that you can refer back to that outlines your commercial position on key legal issues, such as a liability cap, indemnity, termination rights. So you can just refer back to that whenever you receive a contract and you know, see how the clauses align with your commercial perspective. But yeah, really important that either you've got a well-drafted master services agreement in place, or you have some sort of mechanism in place to be able to review carefully any contracts that come through. And again, this just shows your expertise and your professionalism when you're dealing with government and enterprise contracts. And then a few other agreements, making sure that you've got the right, you know, supplier or manufacturer agreements in place, depending on who you deal with. Ensuring that your IP is protected before you enter into any of these arrangements. So if that means having an IP license agreement in place or IP license agreements in place within the company as well, that those are all drafted. And then finally, you want to make sure that you've got the right contracts in place on your website. Now, I think the website is sometimes overlooked, but it probably is super important in the sense that the first place these potentially large clients are going to be looking at when they look into you is your website. So you do want to make sure that you've got your privacy documents in place, which we will touch on a bit further down. But, you know, having a privacy policy, a privacy collection notice, you know, GDPR documents if you are compliant or you're choosing to comply. And then also a website terms of use document, which will govern your relationship with anyone that visits your website. So yeah, by having these documents in place, you look professional, you look well established. And if you've got the privacy documents there as well, you know, you demonstrate that you have that commitment to being open and upfront about how you handle user data. And all of these small things really come together to make you look quite good in front of these larger entities when you're trying to win those contracts. So I know we touched a little bit on employment and contractor agreements, but I'll pass back to my colleague Stephen now to touch a little bit more on the importance of having the right resourcing and staff in place.
Thanks, Ushna. And this point on resourcing and staff is actually quite important, because at the end of the day, these, you know, your personnel, you know, if you do have personnel, it's not just you, will be the ones that actually are delivering the services and will have, I guess, will be part of that critical assessment that a government or enterprise, you know, business is making when they look at, you know, whether you're going to succeed in this tender or not, is can you actually deliver on the required services, and do you have the competencies or the, you know, the minimum requirements to do so? Otherwise, it's essentially a bit of a non-starter. So what they'll be looking for are, I guess, as a minimum, what are the qualifications of the personnel that you'll be putting forward? So you need to make sure that, and it sounds simple, you'll be surprised how often it gets missed, but actually verifying that people or that all your personnel have the necessary qualifications to run these contracts. It's quite common for businesses to maybe not be aware that they need a particular permit or license, or that, you know, a staff member might need a particular type of training in order to deliver a certain, say, service or supply a particular product. And so just making sure that you're really clear on those minimum requirements is fundamental. And then once you have identified that, making sure that, you know, your personnel actually do hold those qualifications, or that they do have those licenses. And the reason we say that is because a lot of these contracts will have audit requirements. They'll want to be able to go and audit your compliance with maybe key contractual principles or key contractual obligations. There may also be a pre-vetting requirement. I've seen a number of contracts where the customer, I guess the client, will need to provide a statutory declaration sort of certifying that all these things are true, that they do have all those permits and they do have all those qualifications. So you don't want to be making sort of a declaration like that without actually doing your own due diligence to ensure that that information is correct. And that kind of flows through to, I guess, if you're doing any work that requires maybe security clearances, obviously in government work, making sure that those are up to date and that you're familiar with the requirements for that as well. And then if you're working in sort of, say, the sector with vulnerable persons, so very common in, say, the NDIS, aged care, you know, working with children, there's a number of sort of checks and things that will need to be in place, whether that be maybe a working with children check, which sort of can vary depending on state and territory and what's been, you know, what work has been performed, but also, say, you know, NDIS worker checks, screenings, things like that, making sure that you have all of those in place as well, especially well in advance of wanting to go out to tender for these things or to kind of bid for this work, because those things can, you know, those are processes outside of your control. And the last thing you want is for your tender to kind of fall over because, you know, those clearances or those checks haven't come through in time. And then I guess as part of that kind of ongoing commitment or kind of having that qualified personnel piece is around training. So there's two parts to it. So one is that some contracts will actually have very clear requirements around ongoing training. And then the other part of it is that ongoing training is actually just a really good risk mitigation tool when we're talking about these sort of contracts that tend to be, you know, higher risk, higher value, you know, on a larger scale. So ongoing training is really important. Sometimes it's required by law, depending on, you know, maybe your profession. You know, lawyers, for example, we have to do ongoing training in order to continue and, you know, maintain our practicing certificates. But also documenting those training efforts as well, so that if you do have an audit, and this goes for audits generally, is, you know, everything's all nicely in one place. You know, it's slick, it's professional, but also it's just not going to be a time and resource strain for you down the line trying to pull information together and piece together what you know might have happened in practice, but isn't nicely documented in a single source of truth. And that also, I guess, with all that in mind, demonstrates that commitment to your, I guess, the quality of the service you provide, your credibility as a business, and maybe as a, you know, as a supplier, and your sort of commitment to quality through continuous learning. So those are really important things that just kind of, you know, we're all human. Everyone sort of has, I guess, more form of view of who they're working with or who they're going to do business with. And those sort of things just help kind of paint you in a more holistic and well-rounded manner when you're applying for these sort of things or bidding for these types of contracts. And I mentioned the capacity point earlier, but that forming strategic partnerships. So, you know, that can be things through maybe recruitment firms, that could be through labor hire agencies, that could be through just the use of subcontractors, are really good to help you expand your expertise when, say, you're bidding for a project that maybe you have, you know, 80 to 90% of the expertise in, but you need to pull in a bit of additional resource or, you know, brain power in order to actually kind of provide that one-stop shop solution to kind of really set you apart from maybe your competitors. So those strategic partnerships with other businesses or professionals can be really useful for that basis. And then obviously, yeah, capacity gaps is a really big one. So it is common to kind of, you know, have all your personnel, you know, maybe get awarded a contract and then, you know, partway through, you know, staff leave, there's turnover, illness, things like that, where maybe you don't have that resource anymore and that can cause delays. Those delays, you know, depending on the contract and how much negotiation power you had, may have, you know, penalties for delays or kind of, you know, issues if delays occur. And so having the ability to pull an additional resource to prevent those delays, or at least mitigate them as much as possible, is going to be really useful. And again, it allows you to bid on those contracts with enhanced capabilities. So again, if you've got 80 to 90% of the expertise, and you just need that one extra bit of expertise to get you there, then these strategic partnerships will be really useful for that purpose. And then the last point I'll touch on is just around key personnel. So there are some contracts that require specific people to carry out the services. You see them quite a lot definitely a lot in the enterprise space, where there's a lot more, I guess, focus on maybe, personal relationships and connections rather than maybe a general tendering or screening process. But they do still appear in the government space from time to time. But these are contracts that require, or there's an expectation that there will be, one person in your business that will be carrying out that service. Maybe they are the best person at that particular type of work or field, or, they're renowned, or there's some personal connection there, and they want you to be the project manager. It's really important just to kind of identify when contracts do have that requirement, and then planning for what happens when, those people leave, because those contracts will either say that you need to, have someone ready to go to jump in to perform that role. And if you don't, then that kind of puts you maybe at risk of contract breach and termination. The other thing as well is that in terms of, I guess, where possible, being able to try and have multiple people be able to fill that role from the outset, in that contract, say, well, could we have at least 2 or 3 people who can be the key personnel for the purposes of this contract, just to give you that flexibility, and also clear processes on how to bring in new people in future, and what happens with offboarding, because they'll also have rights to usually to dismiss not only key personnel, but just any personnel from your business from performing or working on that project is quite common to see too. So having enough resourcing is really important for that. That's enough from me on resourcing. I'll pass back to Ushna on the regulatory requirements, just to touch through some of the key things to think about. And a lot of these are reflected through in those contractual obligations that you'll see in these contracts. So it's really important that you kind of across them and to get those right. So I'll pass to you now, Ushna.
Thanks, Stephen. So regulatory compliance is really non-negotiable, when you're trying to win these larger contracts. And that's for a few reasons. These types of entities, enterprise and government entities, they're obviously quite risk averse, especially when it comes to legal and regulatory risks. So, by partnering with vendors that are non-compliant, they open themselves up to potential legal liabilities, financial penalties, reputational damage. And if you are a business that's quite compliant and quite on top of, your regulatory requirements, that obviously gives these entities a lot more comfort. And also it ensures that any work you're doing with them is going to be continuous and is less likely to face any disruptions in operations, such as shutdowns, investigations, legal actions. If you did face these shutdowns, because of non-compliance, it directly impacts the enterprise client's operations. It can cause delays, lost revenue, and potential breaches of their own contracts. So it's really, really important from that perspective, and for a lot more reasons, that you are on top of the requirements in your industry. And on that, there are quite a lot of industry-specific requirements that we won't be able to touch on today, but it really just depends on the area you're working on, because there is, probably a regulatory body and regulatory standards that you've got to adhere to. For example, if you are in the financial services space, you need to make sure that you're quite on top of the Australian Securities and Investments Commission's requirements. And also, if you're operating in a therapeutic goods space, you want to make sure that you're really familiar with Therapeutic Goods Act and Therapeutic Goods Administration, who oversee the regulation of therapeutic goods. So demonstrating compliance in these industry-specific regulations shows you obviously as an expert in your space. And it gives you a competitive advantage when you're bidding for those enterprise contracts in those specific sectors. There's also corporate governance and ethics that you need to make sure that you're on top of. So, Australian enterprises will often have quite stringent corporate governance and ethical standards that they expect their vendors and partners to also uphold. So regulations, for example, under the Corporations Act and also under the Australian Consumer Law, which ensure that there's fair trading practices and and consumer interests are protected. Making sure that you're complying with those, you're quite familiar with them, and this will show that your business operates ethically, transparently, and that's probably going to be a really key factor when a vendor is trying to decide if they want to partner with you or not. Something we touched on a little bit earlier is privacy and data and the importance of this. You know, as I'm sure we all know, Australia's got quite strict data security and privacy laws, and this is mostly covered by the Privacy Act and also the Notifiable Data Breaches Scheme. Enterprise and government clients, particularly where they're handling sensitive customer data, are really, really cautious about where that data goes and are really cautious about partnering with vendors that don't have the right measures in place to protect that sensitive and, you know, important information and data. So it's really important that you are really familiar with your obligations when it comes to data. So even things like how it should be stored, how it should be handled, how it can be disclosed, and also how long you should be retaining and then deleting that data for is really, really important. So like I kind of mentioned earlier, you want to make sure that you've got a really good privacy policy in place and that this is available on your website. And this talks about, you know, how you collect, store, handle, and disclose data and personal information. Have a privacy collection notice in place, which can be a pop-up that pops up every time you're collecting personal information. And then having an internal data breach response plan. So what that is, it's essentially a internal plan you've got that talks about how your business will handle a data breach if it were to occur. So let's say you've got an employee who has left their laptop on a train. There's, you know, the potential for a data breach to occur, especially if there is important customer information in that laptop. How will your business handle that? Who are the key personnel that will deal with it? And who will make sure that the appropriate report is made to the commissioner if it's needed? So really, really important for you to be across those and also familiar with the Australian privacy principles and what that means for your business. Another really important thing to do in terms of moving forward is make sure that you're developing a system for staying updated on regulatory changes. So that could mean subscribing to relevant industry publications, joining professional associations, or even engaging a compliance consultant. You also want to make sure, and I know Stephen touched on this, but have, you know, the right auditing processes in place, even if that's implementing internal auditing processes to just regularly check your compliance status. And then you should document those audits and also document any corrective actions that you've taken as well. And then finally, in the event that you have sought and to comply with regulatory compliance requirements, you might also consider obtaining relevant certifications that will demonstrate that compliance. All of this is really going to set you an edge apart from any competitors. And it really just means that you look a lot more professional and just a better option for when those enterprise and government contracts are out looking for someone to partner with. Kind of on that general housekeeping point, I'll pass back to Stephen now to talk a little bit more about what more you can do moving forward to make sure that you really set yourself apart.
Cool. So just briefly, I guess just as a bit of a general recap, but also just some key points. So we touched on earlier about the importance of maintaining accurate records. That comes through, I guess, into that second point as well around being prepared for audits. A lot of these contracts will have those audit rights, and depending on maybe the services you provided, or, you know, if you've kind of operating within a very strict budget, things like that, those audit rights typically do get exercised, especially in the government space. Understand the procurement process is obviously really important as well. So making sure you know I guess, not only the timings for how things will progress, you know, when the tender opens, you know, when it closes, you know, are there any sort of opportunities for Q&A with, you know, maybe the tendering entity, especially on the government side. Things can be a bit more, I guess, inconsistent on the enterprise side, depending on whether they have decided to do their own private tendering process or whether they're just sort of, you know, taking expressions of interest, or if it's very ad hoc, it can depend. But understanding what is actually being asked and what they're looking for. It's quite common. I mean, look, we have clients that will come through and say, I want to bid on this tender, and the tender closed a month ago because they haven't actually gone through and read the tender documents. So it's really important to read those for that reason. Is it actually still an active and valid tender? So you're not sort of wasting your own time when you could be focusing on active tenders. But also, I guess, in terms of just, you know, maybe around what the, I guess, the response requirements are. So sometimes, you know, part of those response requirements, they'll want to see other information, you know, about your business, or maybe they're just expecting to see kind of a description of what you can deliver for how much. and, maybe some requested amendments on the contract, which again is why it's important to have an understanding of that timeline so that you have enough time to really negotiate where you can. It can be quite hard because oftentimes, the tendering entity kind of holds the bargaining position. But, with changes in the Australian consumer law around unfair contracts, and things like that, there's a bit more of a movement towards kind of that fairer negotiation taking place going forward. And then it's also just important to build a strong online presence to show credibility. It's all in well sort of having it all in the tender response, but a lot of the time, someone will want to just be able to go online and see, kind of get an idea of your business from maybe reviews that are out there, from what your website kind of has and says that you've done. Things like that can just help build that holistic profile in the market, to kind of really make you stand out. And then just lastly, so on things like insurance, it's really important just to have insurance from a risk mitigation standpoint. Government contracts may, or even enterprise contracts for that matter, may have requirements for insurance that exceed your standard coverage limits. So it's really important to kind of check that is, that your insurance is sufficient. If it's not, maybe speak to your broker or your insurer. And also sometimes too, having them review the liability and sort of indemnity clauses of those contracts can be quite useful just to understand, what risk is maybe insurable and what might not be. A note on government too is that, in some cases, you won't necessarily be screened out because you don't have that insurance yet, but if you will hold that insurance, that is usually sort of the requirement. But to the extent that you already have it, that obviously makes things a lot easier for you in terms of crafting that tender response. And then just lastly, so we've talked about policies. So all these sort of policies are usually required in some of these long form contracts anyway. So anti-bribery, data security policies, general modern slavery, things like that. Having those policies can just be a contractual requirement. And often too, ones we've seen are business continuity plans and disaster recovery plans. Sometimes they're together, sometimes they're separate, really just depends. A lot of the state and territory governments actually have really good starting templates to build these yourself. Because essentially it's about how will your business continue if there was something to happen like a pandemic or a fire or anything like that might kind of interrupt your business operations. And it's obviously really important for the tendering entity because they want to know how will you be able to deliver on the critical services for them, but also just from your own risk mitigation standpoint so that you're able to continue to perform your services and obviously get paid for them. So that concludes the main part of our webinar. We've put a publication here that you might find useful. I think you'll also get a copy in the handout panel as well. So it's just the commercial contracts checklist, which would be really good for just a kind of a general starting point when you get sort of these contracts coming through. You might also be interested in our upcoming event for board and governance responsibilities for NDIS businesses. There'll obviously be some general considerations there just for board and governance outside of the NDIS space. But if you are in that industry, I really recommend that you get registered for this webinar now. We'll answer some questions shortly. I'll give you some time to submit them, but while we do that, we'll just take a minute to tell you about LegalVision's membership. So LegalVision offers a membership where businesses can get access to limited access, to a full team of lawyers. We have specialist lawyers in a whole bunch of fields for your business's usual legal needs. So commercial, regulatory, franchising, employment, you name it. It's basically like having your own in-house counsel, but for a fraction of the cost. We'll sort of assist you with things like unlimited document drafting and reviewing, unlimited legal advice consultations, and also helping with your sort of domestic trademark registrations and things like that as well for a general IP approach. So it's basically, think of it as like having your own in-house counsel. We'll take care of all your business's usual legal work. You can focus on running your business. If you are in-house counsel, we also offer a dedicated service for more of your high volume business as usual legal tasks, kind of like a desk extension, so that you can focus on those more sort of high level strategy initiatives for the business as well. If you do want to learn more about the membership or our sort of enterprise offering, you can request that free consultation in the webinar and have a chat with one of our team about that as well. Cool. So we've had some pre-submitted questions, and I can see there's some questions in the Q&A box as well. So see how we're going for time if we can get through them all. So I'll kick us off. So there's a question that was submitted earlier around how to solve conflicts in reality. So in a lot of these situations, and some contracts will require you to have a conflicts of interest policy as well. But essentially, a conflict of interest is where, maybe some or all of your interests, might differ from that of your own customer, or maybe it's sort of a conflict that arises internally. There are three usual types of conflicts. So we have, I guess, actual conflicts. So where someone has been influenced by a conflicting interest, maybe they're a director of another business that might, benefit or lose from a particular arrangement. The second type is a potential. So there's a chance that you could be influenced by that conflict, that conflicting interest, but maybe you necessarily haven't at this point in time. And then the last one is perceived. So even if you don't think there's any chance of you being influenced, from an external standpoint, you might appear to be, influenced by that conflicting interest. Now, an essential part of managing conflicts of interest is actually knowing how to identify them. So, I guess adopting a conflicts of interest policy is really useful to set out common examples, maybe in your industry or your field, where those conflicts of interest might arise. Having a register of interests is useful as well, just to keep a record of, what conflicts have been disclosed. So you can kind of go back and refer to, that future. Creating and promoting a culture of disclosure is really important as well. So making sure that people are feeling confident and comfortable in disclosing when they might have a conflict is really helpful, obviously, to kind of bring them into the light and identify them. And then when we talk about managing those conflicts of interests, I mean, look, one of the common ones is usually that conflicted individual is not involved, maybe in the project or the discussion regarding any action to do with their conflict of interest. So you see it quite commonly, maybe at a board level, a director might have an interest in a particular transaction. Maybe they are also the director of that other company involved in the transaction, and they'll usually disclose their interest and sort of remove themselves from that, from that situation to kind of, keep that conflict out of it. So that's typically how it will be dealt with, but that identification is really the first step. There's a question here that I think Ushna, you had some thoughts on, which is whether there's a national approach by all states in regard to sort of, I guess, procurement.
Yeah, look, in terms of procuring government contracts, it really just varies on a state by state level. It can even vary at a local government level as well. So no, there really isn't a national approach. And each state's got their own procurement portals and processes. So we'd really recommend that you do a bit of research into your specific state and have a look at resources available online. Generally, government procurement will have guidelines to follow when going out for a tender. And then in terms of on a private kind of enterprise context, there really isn't a consistent approach. Private businesses have a lot more discretion, and there's little public scrutiny or oversight in their procurement processes. So yeah, there really isn't a consistent approach across the board for any of those. Keep your questions coming in, guys. There's a few really good ones coming through. But we did have one earlier, Stephen, if you want to touch on that, about how a business's size influences their likelihood to receive that contract from a government or enterprise department, if you want to touch on that.
Yeah, definitely. So look, there are a lot of clear government guidelines around procurement and not, I guess, discriminating against a business based on their size, or where they're located, things like that. But I guess one thing to keep in mind is that there may be other factors that limit you. So, if I guess your ability to actually deliver and resource the project being the main one. So, in theory, you shouldn't be discriminated against because you're a sole trader. But if the project is of a scale that requires, more than just a sole trader to carry it out, then, that is where those sort of factors should come into play. If you want to have a look at those, you can kind of look. I know the New South Wales government publishes their sort of government procurement guidelines online, and most state and territory governments and the federal government will do the same thing. And you can kind of have a look through at all the, I guess, minimum expectations for, government departments and agencies when they conduct these procurement processes around, discrimination, considerations, things like that. So I really recommend giving those a look. There's, I guess, a question here around government service contracts and how they don't typically allow deviations from their standard terms and conditions. So I guess around what risk mitigation measures, could take place in those circumstances. And this actually ties in nicely to an earlier question we had around negotiating out of excessive liability. So Ushna, do you want to sort of speak to that point?
Yeah, that's a really important one. And yeah, you're absolutely correct. Usually there isn't much scope to negotiate those terms. Look, I guess to start off, you want to make sure that you've got a lawyer on your side so that when you do have those contracts come through, we're able to review those from you. And because we've got experience working, with enterprise and government entities, we can provide you with advice on, A, what the risks are in the contract that you're signing, and also B, if there is scope, because sometimes you might be surprised, we might be able to negotiate some of those clauses for you. So really important that you've got us to deal with that for you. But another way that you can really mitigate that is, again, we touched on this earlier, but making sure that you've got back-to-back liability clauses with any subcontract agreements that you've got. For example, if an indemnity is being sought in a head contract, in the favor of the enterprise client, passing on as much of that liability as possible to the subcontractor. And making sure that they're liable, especially if there's something that goes wrong from their perspective. So that's one way that you can manage that risk. But another really key thing is that with time, you do kind of start to become a little bit more familiar with, in practicality, what's actually going to be a risk for you. And on the ground, when you're performing those services, what's actually really going to come into play. So you do learn that over time. And again, that's something that we're able to provide you with advice on as to kind of what's worth your time trying to negotiate and what's not. But yeah, this is a really, really big question. And we kind of deal with this on a day-to-day basis. So definitely would be more than happy to help you out further, if you were to become a member and join us. And I might just quickly also touch, because it kind of ties into this, but somebody sent earlier asking how you ensure that scope creep doesn't happen in service contracts. And this does tie into, again, your risk profile. You want to make sure that you've got really, really clear statements of work in place that outline exactly what services you're going to provide, even what services are excluded, and then also having clauses in the agreement that talk about variations and what the process for a variation might be, how would the fees be reviewed in the event that there were variations, how would requests for variation be put in. So having all of those right in the beginning in a contract that's signed by both parties ensures that, the likelihood of scope creep is very, very low. We might just have time for one more question. So Stephen might touch a little bit on some certification requirements that somebody had sent through.
Yeah, I'm going to try and squeeze in two, so wish me luck. So there was a question submitted just around how do tendering entities actually see or ask to see those employee and contractor contracts. So that comes up in a few ways. So one way is in terms of, I guess in those contracts, there'll usually be requirements or restrictions around engaging subcontractors unless you get consent. We've definitely seen contracts before where that consent is kind of conditional on maybe seeing the contract that will be entered into or approving the form of contract that will be entered into. So that's one way that you might see it. Sometimes they may prescribe a form of contract. It's not as common, but it does happen from time to time. The other thing too is that in those auditing processes, so when they're wanting to audit your compliance with the agreement, and they'll say that, all your contracts need to have, these things, that's what they, might have that right to go and check. So some of it's kind of, I guess, once the contract's on foot. Sometimes we've also seen before the contract's even entered into, they'll want to know maybe who you're planning to subcontract to or engage as part of the project. And, particularly in enterprise, there's, I guess, a bit more remit to ask for lots of things is around, they might actually want to see the contracts that you'll be looking to engage in before they actually kind of give you the master contract. One other thing I'll add as well is that there are situations where you might still be dealing with a government agency, but maybe it's sort of lower down the chain. I've had clients that have dealt with maybe, smaller health outfits and things like that, where the client has actually proposed their own contract and that's been accepted, but it's obviously really important to have that contract looking, kind of slick and watertight so that it's perceived well when it kind of comes through to the, maybe the government legal team or anything like that, just so that, alarm bells don't go off internally. As lawyers, if we see contracts come through that kind of aren't up to scratch, it does raise a question about maybe sort of other areas of the business as well. So it's just really important to keep in mind. And then just the last point that I wanted to add was just on those certifications. There's sort of two questions asked around, is it worth being, say, ISO certified? There's one, 9001 around quality management systems, and then 27001 around information security. They're definitely useful. Some contracts will have them as a requirement. I definitely see the information security stuff becoming more popular as a kind of obligation to have in terms of, cybersecurity, data breach protections, things like that. So It's not always required. I've seen clients negotiate out of it as well. So it's in their contract and they've kind of said, oh, we've got these other certifications, or, it doesn't really matter because we've got this type of technology, and they've managed to negotiate around them. So it's not always consistently required. I guess if it is, and you don't have it, it's probably a barrier, but there are ways in which you might be able to satisfy sort of someone that you can kind of, maybe why you don't need it. So it's not necessarily something you should always write off, but it's definitely worth, if you have the opportunity to have a conversation about, maybe through kind of a pre-tender Q&A, definitely worth doing. I've noticed that we're on the Q2, so we've run out of time for the further questions. If you haven't answered your question, then feel free to use that consultation to maybe have a chat with one of our team to speak to a lawyer. Otherwise, we value your feedback, so please complete the 30-second survey at the end, and hopefully we'll see you on another webinar sometime soon. Thank you.
Thank you.